The Supreme Court's ornate chamber fell into a hushed silence as Representative Jasmine Crockett approached the crucial point in her oral argument. The rare congressional appearance before the nation's highest court drawing unusual attention as the freshman congresswoman from Texas represented her constituents in a case challenging controversial voting district maps that civil rights organizations argued diluted minority voting power in violation of the Voting Rights Act. For nearly 15 minutes, Crockett navigated complex legal questions with the practiced precision of someone who had spent years litigating constitutional issues before entering politics. Her presentation methodical yet accessible, balancing technical legal analysis with clear explanations of real-world impacts that several justices appeared to find compelling. The district maps at issue before this court today exhibit precisely the kind of discriminatory effect that Section 2 of the Voting Rights Act was designed to prevent. Crockett explained with remarkable command of statutory language and relevant precedent. Statistical evidence, she continued, demonstrated that these boundaries divide cohesive minority communities into separate districts where their voting power is consistently overwhelmed by majority blocs, creating exactly the sort of dilution this court recognized as actionable in Thornburg versus Gingles. As she built her argument connecting specific district boundaries to measurable voting impacts, Crockett carefully addressed the court's recent narrowing of Voting Rights Act applications, while emphasizing the particularly stark evidence in the present case. She had just begun addressing Justice Barrett's earlier question about standards for identifying intentional discrimination versus discriminatory effects when Justice Samuel Alito abruptly cut her off mid-sentence. "Counsel," Alito interjected with the slightly impatient tone that lawyers who regularly appeared before the court had come to recognize. "I'm struggling to understand how your argument is meaningfully different from asking this court to require proportional representation, which the text of Section 2 explicitly states is not required. Aren't you essentially arguing that any district map that doesn't maximize minority electoral success violates federal law?" The interruption's framing, suggesting Crockett was advocating a position directly contradicted by statutory text, represented a particularly challenging form of judicial questioning that seemed designed to undermine the fundamental premise of her case, rather than seeking clarification of a specific point. The chamber's atmosphere instantly tensed as observers recognized the significance of both the interruption's timing and its characterization of her argument. Crockett paused briefly, her expression reflecting not defensiveness, but strategic consideration before responding with remarkable composure. "Justice Alito, with respect, that characterization fundamentally misrepresents both my argument and the evidence before this court." She began with measured precision that maintained appropriate deference while directly addressing the mischaracterization. "I am not advocating for proportional representation or maximizing electoral outcomes, but for compliance with this court's established three-part Gingles test for identifying unlawful vote dilution. The evidence demonstrates that these particular districts destroy previously cohesive minority communities that had existed for decades by dividing them precisely at their demographic centers and combining each segment with overwhelmingly majority populations in ways that preclude any meaningful electoral opportunity." Without raising her voice, but with unmistakable clarity, she continued, "The record contains statistical analyses demonstrating that mapmakers could have created 17 different configurations that better preserved community boundaries while meeting all traditional redistricting principles. Yet they selected the only configuration that consistently prevented minority communities from meaningful electoral participation despite their population size and geographical cohesion. This isn't about guaranteeing outcomes, but preventing the precise sort of targeted dilution that Section 2's plain text prohibits." As Alito began to interject again, Crockett maintained her composure while continuing, "If I may complete my response, Justice Alito, the distinction between unlawful dilution and proportional representation is precisely why this court established the Gingles test rather than using simple demographic proportionality. The evidence here satisfies each Gingles factor, geographically compact and politically cohesive minority communities facing consistent defeat by majority blocs, with district configurations that cannot be explained by traditional redistricting principles when numerous alternatives existed that would have better preserved community boundaries while maintaining population equality. Alito's expression reflected growing impatience as he interrupted again, this time more forcefully. "Counsel, you've repeatedly referenced community cohesion, but the Constitution protects individual voting rights, not group rights. Doesn't your emphasis on preserving certain communities as voting blocs itself reflect a concerning form of racial essentialism that assumes people must vote according to racial identity, rather than individual policy preferences?" The framing of this interruption, shifting from statutory interpretation to suggesting Crockett's position reflected racial essentialism, represented an even more fundamental challenge that questioned not just her legal analysis, but the conceptual framework underlying voting rights jurisprudence itself. The chamber grew even quieter, as observers recognized this was no longer routine questioning, but a direct confrontation over the foundational principles of voting rights law. Crockett remained perfectly composed as she responded, "Justice Alito, with sincere respect, that question conflates analytically distinct concepts. Section 2 analysis doesn't presume how individuals must vote, but empirically measures demonstrated voting patterns to identify whether district boundaries interact with social and historical conditions, to deny equal opportunity. The evidence here isn't speculative, but reflects documented voting behavior across numerous elections, showing that these specific communities have consistently expressed shared political preferences that these districts precisely fragment." As Alito's expression suggested continued skepticism, Crockett delivered the response that would be quoted in law school classrooms for years to come. "More fundamentally, Justice Alito, the Voting Rights Act exists precisely because our nation's history demonstrates that pretending not to see race when drawing electoral boundaries has never meant race wasn't seen. These maps reflect surgical precision in dividing specific minority communities that had voted cohesively for decades while meticulously preserving majority community boundaries. When mapmakers demonstrate they clearly saw race in drawing these boundaries, constitutional fidelity requires that courts not blind themselves to that same reality when reviewing them." The chamber remained completely silent as she delivered her final point with perfect judicial deference that nonetheless contained unmistakable moral clarity. "The question before this court isn't whether the Constitution protects group voting rights in the abstract, but whether the Voting Rights Act prohibits district maps drawn with such surgical precision that they divide previously cohesive communities exactly where demographic patterns shift, and whether courts will acknowledge that precision when it appears in district boundaries, but refuse to see it when reviewing those same boundaries. Equal justice under law inscribed above this very court surely requires at minimum that courts not selectively blind themselves to realities that mapmakers so clearly saw. The complete reversal transforming Alito's interruption from a challenging question that seemed designed to undermine her position into an opportunity to articulate the moral and constitutional principles at the heart of voting rights. Jurisprudence created what legal observers would later describe as one of the most significant moments of clarity in modern voting rights arguments, as several justices visibly reacted to the precision and power of her response, with Justice Kagan notably nodding and Justice Sotomayor leaning forward with heightened attention. It became clear that what had begun as a challenging interruption had become an opportunity for Crockett to articulate the core constitutional principles at stake with a clarity and moral force that transcended technical legal analysis. Before we dive deeper into this explosive confrontation that has everyone talking, don't forget to like this video and subscribe to our channel. Hit that notification bell so you never miss our in-depth analysis of the most revealing moments in Supreme Court arguments that mainstream media often glosses over. Now let's get back to the remarkable exchange where Representative Jasmine Crockett's measured response to Justice Alito's interruption completely transformed what could have been a defensive moment into a defining articulation of voting rights principles that left the Supreme Court chamber in stunned silence, with its moral clarity and constitutional precision. Jasmine Crockett's path to that pivotal moment before the Supreme Court reflected an unconventional trajectory in American legal advocacy. Elected to Congress in 2022, after serving just one term in the Texas state legislature, the 41-year-old attorney had maintained her legal practice alongside her political responsibilities, continuing to litigate civil rights cases while serving as an elected representative. What casual observers often missed when focusing on her relatively recent arrival on the national political scene was her extensive background in voting rights litigation long before seeking elected office. Before entering politics, Crockett had built a reputation as a meticulous voting rights litigator who emphasized comprehensive factual development alongside legal theory, particularly in cases involving complex statistical evidence of discriminatory impact. Her approach to legal advocacy had always prioritized empirical evidence over abstract legal principles, recognizing that voting rights cases typically turned on courts' willingness to acknowledge factual patterns rather than simply accepting jurisdictions' facially neutral explanations. Though appearing before the Supreme Court for the first time, she approached oral argument with the same evidence-focused preparation that had characterized her litigation career, where command of specific factual details often proved more persuasive than general legal principles in establishing Voting Rights Act violations. Justice Samuel Alito, by contrast, had established himself over 17 years on the court as one of its most forceful questioners and consistent skeptics of expansive voting rights interpretations. Throughout his tenure, he had developed a jurisprudential approach that emphasized narrow textual interpretation of the Voting Rights Act while expressing particular skepticism toward claims based on discriminatory effect rather than proven intent. His questioning during oral arguments often reflected these perspectives, frequently challenging advocates to defend positions that emphasized historical patterns or statistical disparities rather than explicit discriminatory statements. The case that brought them into this extraordinary exchange involved a challenge to congressional and state legislative districts in a southern state following the 2020 census. Civil rights organizations had presented extensive statistical evidence showing the district boundaries had been drawn to precisely separate, previously cohesive minority communities in ways that prevented effective electoral participation despite their substantial population and geographical concentration. The legal question centered on whether these district configurations violated Section 2 of the Voting Rights Act by denying minority voters equal opportunity to participate in the political process, particularly given alternative maps that would have better preserved community boundaries while meeting all traditional redistricting criteria. For 15 minutes, Crockett had presented a methodical analysis, connecting specific district boundaries to measurable voting impacts, carefully addressing the court's recent narrowing of Voting Rights Act applications, while emphasizing the particularly stark evidence in the present case. Her approach had balanced technical legal standards with accessible explanations of real-world effects in ways that several justices appeared to find compelling based on their engaged questioning. The pivotal moment came when Justice Alito interrupted her response to Justice Barrett's question, shifting the discussion from specific evidentiary standards to more fundamental challenges of her conceptual framework. The exchange that followed not only defined that day's session but quickly became a touchstone across legal circles, illustrating how disciplined advocacy rooted in fact and precedent can transform even the most adversarial questioning into a powerful reaffirmation of principle. By the evening, transcripts and recordings of the exchange had gone viral, scholars and civil rights leaders alike pointing to Crockett's clarity, composure, and moral precision as a model for a new generation of advocates. Her words, calm, factual, unflinching, reframed the entire debate around what it truly means for the court to see or not see race in the law. If you found this breakdown of one of the most significant exchanges in recent Supreme Court history informative, please like this video and subscribe to our channel. Hit that notification bell so you never miss our in-depth analysis of pivotal moments in constitutional advocacy that reveal deeper patterns in our ongoing national conversation about equal justice under law. And leave a comment below with your thoughts on voting rights jurisprudence, and the importance of courts acknowledging the same realities that mapmakers clearly see when reviewing potentially discriminatory district boundaries.